Hello and welcome back to Faceless Security, where we explore the world of technology and cybersecurity. In this video, we will explore another law designed to safeguard intellectual property, import-export controls, the flow of data across borders, and unraveling the intricacies of various laws and regulations dedicated to safeguarding personal information. Prosecutors face challenges in defining and prosecuting computer crimes, which is why they often rely on traditional criminal statutes, such as theft, fraud, extortion, and embezzlement. Additionally, laws related to intellectual property rights and privacy exist to protect the public and aid in prosecution. The four types of intellectual property protected by U.S. law are patents, trademarks, copyrights, and trade secrets. Patents are legal protections granted to inventors for their inventions, such as new products, processes, or machines. Patents give inventors the exclusive right to make, use, and sell their inventions for a certain period of time, usually 20 years from the date of filing. To be granted a patent, an invention must meet certain criteria, such as novelty, non-obviousness, and usefulness. Trademarks are symbols, logos, names, or other identifiers that are used to distinguish the goods or services of one company from those of another. Trademarks are protected under U.S. law and give companies the exclusive right to use their trademark in connection with their products or services. Copyrights protect original works of authorship, such as books, music, and computer software. Copyrights give authors the exclusive right to reproduce, distribute, and display their works. In the context of computer crimes, copyright infringement occurs when someone uses another person's copyrighted work without permission, such as by copying software, music, or images. Trade secrets are confidential information, such as formulas, processes, or customer lists that give companies a competitive advantage. Trade secrets are protected by law and can be subject to civil or criminal penalties if misappropriated or stolen. Overall, intellectual property laws are an important tool for protecting creators and innovators and preventing computer crimes such as theft of trade secrets or copyright infringement. Working with other companies in different parts of the world adds complexity to an organization's import and export laws. These laws vary across countries and may include restrictions on sensitive technologies like cryptography, advanced electronics, computers, and telecommunications equipment. To prevent the buildup of military capabilities that could threaten regional and international security and stability, the Wassenaar Arrangement is an international treaty that imposes export controls on conventional arms and dual-use goods and technologies like cryptography. The agreement applies to 42 countries and lays out rules on how certain items can be exported from country to country. The categories of items covered by the Wassenaar Arrangement include: Category 1. Special materials and related equipment. Category 2. Material processing. Category 3. Electronics. Category 4. Computers. Category 5. Part 1. Telecommunications. Category 5. Part 2. Information security. Category 6. Sensors and lasers. Category 7. Navigation and avionics. Category 8. Marine. Category 9. Aerospace and propulsion. Exporting products with cryptographic functionality to countries that may have ties with terrorist organizations or plan to use weapons of mass destruction is a danger that the agreement recognizes. Countries that allow bad countries to use cryptography cannot monitor their activities. The Wassenaar Arrangement specifications are complex and always changing, and some countries, like China, Russia, and Iran have cryptographic import restrictions that make selling products with integrated cryptographic functionality complicated. The United States has two key laws that address the export of prohibited technologies: the International Traffic in Arms Regulations, ITAR, and the Export Administration Regulation, EAR. ITAR prohibits the export of items designated as military and defense items, while EAR prohibits the export of commercial items that may have military applications. Many countries restrict the import or export of certain advanced technologies. Each country has its own laws and regulations governing the import and export of advanced information technologies. Cybersecurity professionals need to be aware of relevant import-export controls for any countries in which their organization operates or to which their employees travel. Advanced encryption technologies falling into the hands of terrorists, criminals, or declared enemies of a country can have severe impacts. Countries declare which technologies may or may not be imported or exported to or from them based on their best interests. Therefore, the Wassenaar arrangement should be consulted prior to export, based upon the laws of both the importing and exporting countries. Transborder data flow refers to the movement of data across political boundaries. The issue of transborder data flow is important for organizations operating in the public cloud, as they need to know where their data is stored and have control over it. Data residency and transborder data flow should be addressed in agreements with cloud service providers. Many countries restrict or prevent export of their citizens' personal data due to varying data privacy and breach disclosure laws. This issue is particularly relevant for organizations outsourcing to service providers. Security and privacy professionals need to understand where their data physically resides to ensure compliance with privacy laws. Some countries have data localization laws that require certain types of data to be stored or processed within their borders. These laws may be intended to protect people or restrict and control access to data for reasons such as censorship, national security, or other motivations. While international agreements control some cross-border data flows, there are social, political, and technological concerns over their effectiveness in different privacy rights and technologies such as cloud computing and the globalization of IT. Cloud computing services have become an important tool to address data localization concerns in a cost-effective manner. Major cloud service providers offer an increasing number of regions where data is guaranteed to remain, sometimes down to individual countries. However, data localization can increase the cost of doing business in certain countries, as organizations may have to provision and protect information systems in those countries that they otherwise wouldn't. Privacy is concerned with preventing the unauthorized use or disclosure of personal data, also referred to as personally identifiable information, PI, including financial data, health records, and other unique personal characteristics. Every organization that collects any personal data must have a published privacy policy that explains why the data is being collected, how it is being used, how it will be protected, and what each person's rights are. Employee privacy issues, such as monitoring, search, drug testing, and other policies, are common and can be addressed by clear policies that define acceptable use policies, monitoring purposes, acceptable behavior, and potential disciplinary actions resulting from violations. Several privacy-related laws and regulations that are designed to protect personal information and data of individuals in different contexts. The U.S. Federal Privacy Act of 1974 regulates how federal agencies collect, use, and disclose personal information about individuals, and it also gives individuals the right to access and amend their records. The U.S. Health Insurance Portability and Accountability Act, HIPAA, of 1996, on the other hand, sets standards for the privacy and security of protected health information and it requires covered entities to implement administrative, physical, and technical safeguards to protect the confidentiality of health information. The U.S. Children's Online Privacy Protection Act, COPPA, of 1998, aims to protect children's privacy online by requiring website operators to obtain parental consent before collecting personal information from children under the age of 13. The U.S. Gramm-Leach-Bliley Financial Services Modernization Act, GLBA, of 1999, regulates how financial institutions collect, use, and disclose personal financial information of their customers. The U.S. Health Information Technology for Economic and Clinical Health Act, HITECH, of 2009, expands the privacy and security provisions of HIPAA and strengthens the enforcement of these provisions. The California Consumer Privacy Act, CCPA, of 2018, gives California residents certain rights over their personal information, including the right to know what information is being collected about them, the right to have that information deleted, and the right to opt out of the sale of their information. The California Privacy Rights Act, CPRA, of 2020, builds on the CCPA and provides additional privacy protections for California residents, including creating a new enforcement agency to oversee privacy violations. The UK Data Protection Act of 1998 regulates how personal information is processed and used in the UK, and it also gives individuals the right to access and correct their personal information. The European Union General Data Protection Regulation, GDPR, of 2016, is a comprehensive privacy regulation that applies to all organizations that process personal data of individuals in the EU. It gives individuals greater control over their personal data and requires organizations to implement appropriate technical and organizational measures to protect personal data. In conclusion, it's crucial for security professionals to be well-versed in the various privacy and data protection laws and regulations that may differ from country to country, particularly when conducting international business or traveling. Adhering to these laws is essential to protect personal data and prevent legal consequences. Organizations must also exercise due care and diligence to ensure compliance with these regulations to avoid legal penalties or harm to their reputation. It's essential for businesses to prioritize data protection and privacy to build trust with their clients and partners. Thank you for watching. Be sure to like, comment, and subscribe for more great content from Faceless Security.